Hi there. I'm Joryn Jenkins. I'm your marketing coach. This is one of the posters that I've created especially for young lawyers, but basically for lawyers who are talking to their clients about what to expect from a mediation. Many clients never get this talk, this realistic expectations talk about what mediation consists of and what they can sort of expect. This is not, by the way, about the mediation process. It's more about what mediation looks like in a picture. So you have a picture of litigation and a picture of mediation. So I'm comparing and contrasting, just like fifth grade, the two processes. And I think this poster will help your clients understand, and it gives you a basis for discussing what they're going to do in mediation, where they're going to go in mediation, what that's going to look like for them. So I talk about in this poster, on this side is litigation and the courtroom. On that side is what mediation looks like. In the middle is the distinction that we're talking about. So at the top, you've got the judge's role. Is it a judge? It's a decision maker. So in the litigation process, a judge who doesn't know you or the other party or share your values makes the decisions for you based on a limited amount of information he hears during a brief trial. Whereas in mediation, this is generally conducted with a single mediator who does not judge the case, doesn't make any decisions, but simply facilitates discussion and hopefully eventual resolution. And quite often, by the way, the parties choose the mediator. Judges are assigned, of course, by the system, the justice system. What's the atmosphere and how does it differ in litigation versus mediation? Well, in litigation, it's positional, it's adversarial, it's hostile. In mediation, it's somewhat more relaxed, it's more peaceful, certainly more peaceful than litigation. What about the level of conflict? Same idea. Litigation is hostile and adversarial, sometimes disrespectful. Mediation, parties are encouraged to freely and confidentially present their positions in front of a neutral third party, the mediator. How about the cost? Well, litigation is unpredictable and post-judgment litigation is not unusual and it's costly as well. The cost of mediation in comparison is usually much less expensive. I can't give you numbers because it depends on where you live and who you've hired, but you can certainly compare and contrast that item. Time. What about time? Litigation can go on for years. In litigation, the judge's docket mandates the timetable, and that's also controlled by when your lawyers, more than one, are available, the other side and yours. So crowded dockets by the judges cause regular delays. Typically, mediation takes less time than litigation because the parties have more control of the process. You've chosen the mediator. You can choose the mediator according to his availability. Quite often, we do our civil mediations in 8 hours or less, maybe in a couple of days, maybe. But litigation can take years. And then what about the experts? So in litigation, separate experts support your positions. Non-transparency requires the experts to work harder. In mediation, you can jointly retain experts. You can do that in litigation too, by the way, but it's not usual. You can jointly retain experts to guide you, to help you develop transparent solutions. What about the lawyers? Well, in court, the lawyers are fighting to win. And it's often a lose-lose situation, by the way. In mediation, the lawyers are trying to problem solve to help you get to a resolution that you can live with. Basically a win-win agreement if you can. So the role is a little bit different, even though it's the same guy. So don't be surprised if your lawyer in court is very adversarial and hostile. That's his role. He's your advocate. In mediation, don't be surprised if he's more problem-solving oriented and trying to help you get to resolution, right? Confidentiality. Litigation is public and subject to media attention. Mediation, quite often you can make sure that whatever is said in mediation is confidential. In fact, here in Florida, they're always confidential unless something specific happens that is outside of confidentiality. Communication. The court process discourages communication between the actual parties to litigation. Mediation, the mediator will often educate and assist both parties to communicate with each other to actually get to resolution. What about the nature of the process? Well, litigation is mandatory if you don't choose another process, whereas mediation is often voluntary. We often will voluntarily take our clients to mediation if we think we can resolve the case that way, because it costs so much less for our clients, and so they're a lot happier. And then conflict of interest, well, I mention this because lawyers make more money when we litigate. We just do. We make a, I can't say, I don't like to litigate because my clients often end up unhappy because it's a lose-lose situation, but I make lots of money. I like it. If we mediate successfully, well, we may have mediated during the litigation process, so we may have already made some substantial money. But mediation, because it takes so much less time, is usually, even though you're using a mediator who costs you money also, it usually ends up costing you a lot less in the long run. So, and then the skills required. Well, advocacy and strategy skills in litigation, whereas problem solving and communication skills in mediation. So the processes are very different. My clients, before I made this poster to help me talk through the process with them, were often confused by the change in my mask. So I went from being the advocate on the white horse with the lance and the shield to being the problem solver and really trying to help them understand the other side, which you don't do in the courtroom. And so when they were confused by that, I realized I really needed to explain the mediation process better, and this poster helps me do it. Hopefully it will help you as well. I'm Joryn Jenkins. I'm your marketing coach.